Okay, let's get started. Once again, welcome, and thanks for joining today's session, Fiduciary Responsibilities and Inheritance Advances, a new probate tool for probate professionals, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. The presenters will address questions after the presentation. If your question is case-specific and confidential, please indicate that in the chat, and someone will respond separately after this presentation. Our presenters today are professionals with extensive experience in all aspects of providing cash advances to individuals awaiting inheritance payouts. Mark Harris has been working in the specialty finance industry for 25 years, involved in purchasing over $100 million of assets. Most of his purchases, pursuant to various state laws, required court hearings, many of which Mark has either attended or appeared as counsel. As a result, Mark has had the advantage of meeting customers, their lawyers, and establishing relationships to find collaborative solutions for the customers. Mark has spoken at conferences including the National Association of Insurance Commissioners and the National Council of Insurance Legislators. Mark earned his undergraduate degree from Florida State University and law degree from Nova Southeastern University in Fort Lauderdale. Today, he's here to speak about the relatively new business of purchasing interest in actively pending inheritance claims from estates or trusts. What are some common misconceptions about a probate advance?
Let me be clear what this is not. We're not talking about interest in life insurance on or property owned by someone still living. Thus, we're not talking about buying senior settlements or remainder interest in real property. Those are different businesses, not what we're discussing today. These are also not intended to be transactions where we buy out an heir's entire position or interest. The goal here is to provide the recipient with interim cash sufficient to meet their current needs while still keeping the heir in the game, looking forward to the ultimate windup and distribution of the estate. We want the ultimate settlement of the estate and distribution to remain an interest to and a priority for the heirs we fund. Finally, this is not a loan. There's no fixed due date, no interim payments of principal or interest due, no stated rate of interest, fixed or variable, and no personal liability on the part of the recipient if the estate turns out to be insolvent or if the proceeds distributed to the heir come up short of what was originally anticipated. The only situation where we're going to have a claim against a recipient is where the estate pays out, the recipient gets a hold of their inheritance and doesn't pay us. That's just stealing. Or if someone flat out lied in the first instance about who they were with the relationship to the estate, that's just fraud, and we will try to get our money back. But if the property sales are disappointing, or the amount of outstanding debt eats up the proceeds, or it all ends up taking years before a distribution, well, that's our risk.
What were your initial thoughts when you heard about advances on inheritances?
I've been in businesses for about 25 years that focus on providing upfront money to people who are waiting for future cash flows. Therefore, I thought this business made total sense, both for beneficiaries waiting for money and for the lawyers and trustees who are working with those beneficiaries. Clearly, probate is not as predictable as one might think, nor does the layperson understand the probate process and how much time it takes to finally obtain an inheritance. The average person believes that shortly after a death, there's a reading of the will by some lawyer, and the beneficiaries then leave that lawyer's office with their inheritance. At least that's the way it's usually portrayed on TV and in the movies.
If beneficiaries take an advance against their inheritance, how does that benefit the trustee, or is this just another hassle?
Much of our business is referred to us by probate lawyers, trustees, realtors, and other professionals. In fact, most such professionals are grateful that we offer this service, and here's why. The lawyers and trustees are regularly being called by anxious heirs. These heirs don't understand the probate process nor why it takes so long. Frankly, they're only interested in receiving money now, and they want immediate answers and when they're going to receive their inheritance. Most of those folks on this call have experienced firsthand the repeated phone calls, emails, and sometimes unpleasant and disrupting communications from beneficiaries. ProbateCash can be a solution that eliminates or curtails those disruptive communications to your office by providing those anxious heirs money today and waiting to be repaid only when the assets are ready to be distributed. Referring heirs to ProbateCash relieves financial pressure on beneficiaries that cause them to frequently call your office about why they still don't have their inheritance.
Does the estate have to have cash or other liquid assets?
In many instances, real property is the significant asset of the estate or trust. In fact, it's this illiquidity that causes heirs to pursue in advance to prepare for the sale of the property and to wait for that sale to close. Heirs and beneficiaries often need access to funds, but there are limited estate resources from which a preliminary distribution can be done. If you practice in a state where property is homesteaded, we can still work with advances to beneficiaries. Ultimately, can we proceed with the cash estate? Of course. Is an estate or trust required to have cash assets? Not at all.
If you were the trustee and a beneficiary called and asked you about doing a probate cash advance, what would you say to them?
Well, I guess it would depend on whether the question came from my client or from a beneficiary who's not my client, but still kind of a constituent. In either case, I might offer the standard qualifications about not substituting my business judgment for theirs. If it was my client, I might briefly explain the process, note that this kind of advance can come with a significant cost at the end, and ask if they had any other sources of cash to meet their immediate need. If the question came from a beneficiary of the trust who's not my client, I would explain the cost of taking the money early from the trust. I also know that all beneficiaries want their money as quickly as possible without regard to probate or other issues, of course. But emergencies happen in life, and obtaining money that's stuck in probate or a trust is often very important to those beneficiaries who are facing life's challenges. If they were intent upon proceeding, I might admonish them not to take more of an advance than required to address their identified need.
So the first question, it looks like, is, and I think it's probably one on everyone's mind, how much does it cost?
That's always on everybody's mind. So very relevant. Our standard practice is to charge quarterly fees capped after 12 to 15 months. So if an estate takes longer than 15 months, there are no additional fees charged to the beneficiary. Depending on how much cooperation we receive from the estate counsel or a trustee, our fees can be adjusted to reflect the risk of the advance. So the advance fees start at about 15% of the advance amount.
Great, thanks, Mark. And we have another one here. It says, are there any laws that govern inheritance advances?
There are. There's one. California is the only state in the country that has a statute pertaining to assigning an inheritance. It's California Probate Code 11604. More importantly, no states prohibit these assignments, and we do follow the spirit of California's code in each state, complete with filing the assignment with the probate court and all consumer safeguards incorporated in California's code. If it's just a trust, we provide, I think as Karen mentioned in our earlier here, is we provide the assignment to the trustee.
Another one we have here is talking about cooperation. It says, providing cooperation can take time. Will ProbateCash reimburse the trusts for my time?
So I'll answer that one. I know, certainly as well as anyone, that lawyers and trustees sell their time. We'll reimburse you up to 1 hour for your time if you have to review documents with us to make sure the advance can be done.
And I want to double check that we got everyone's questions. I think we did, but I just want to double check. And it looks like we did. And again, if you think of anything else, we'll be sending out a follow-up email with an e-brochure, ProbateCash, and a link to the webinar. Or if you're like me and the question pops up 15 minutes after this ends, you can contact Mark offline, or you can call Mark at 561-476-0018, or email him at Mark, and that's MARC @probatecash.com. And thanks for joining us, and have a great day.